Yes, Mr. King.
May it please the court, I appear on behalf of the appellant. I'm going to try the best to pronounce his name correctly. It's apparently Mr. Kocur.
Kocur, thank you.
In the break, you may well tell me I mispronounced it, but it's certainly not Mr. Kocur. Appearing on behalf of the respondents are my learned friend, Mr. David Reed, QC, and he is leading Mr. Graham Anderson. My lords, as you'll appreciate, this appeal is about the correct interpretation of Regulation 13.1 of the Agency Worker Regulations 2010.
Yes.
Now, we'll set out our stall at the outset. Our contention is that it is not merely a right to be informed, obviously the respondent's position, but also a corollary right to apply. That is, the information given has to give the appellant or any agency worker an opportunity to get the job. And I'll come back to that phrase later. At the outset, before dealing with the rough outline that I suggest to make, we make two observations.
Just before you do, sorry
yes,
for interrupting you, the nature of the right conferred, I just want to be clear I've understood it. So right not only to be informed, but right also to apply.
Yes.
Do you submit also that it's a right to be considered?
Yes.
Once you've made your application?
Yes, because if effectively, otherwise, my lord, it's a moving target. It just gets one fiction to another. They would say, okay, we now accept you have both the right to be informed and apply, but we will automatically reject you for the very reason that is your status that we said at the outset. So otherwise, our effectiveness arguments or our purpose arguments, whatever label you wish to put on them, would be thwarted.
And I know you haven't started, but you do accept that an employer can impose selection criteria. So you can be notified, apply, but then automatically rejected because of the selection criteria.
Absolutely, my lord. The distinction is the selection criteria cannot be solely based on your status. So in other words, if the selection criteria is having a certain qualification and the agency worker applies and doesn't have that qualification, so be it. If, to give an example in this case, they want to award length of service or commitment, that can still be achieved by an agency worker. What they're looking at is how long they have worked for this hirer, because you can get a conceivable situation, which in fact is this case, or sometimes this case, we didn't quite get all the way through to remedy, where you have a very long-serving agency worker who's been there several years, and the comparable worker may have been there for a very short period of time, let us say only a month or so. If the intention, the criteria is to encourage loyalty on length of service, that can still be honoured. And later on I'll deal with Coles and the redundancy arguments, that criteria can also still be honoured because it applies equally across. In other words, dealing with that point up front, if you wish to have a redundancy pool for very good reason, the criteria is the first round, as it were, preference is given to those who will be made redundant. Now the comparable worker in the employee status workforce who's not going to be made redundant is put in the same position as the agency worker. However, the nature of redundancy is that sometimes, believe it or not, no one wants to apply for that job. Don't know why, but that sometimes happens. And on that occasion, there'd be the comparison.
It's quite a complicated model that you are postulating. So apply notification, which is in the rules. So we've got to imply by reference to purpose a right to apply and a right to be considered subject to selection criteria.
My response to that is, to be blunt, discrimination is a complicated model anyway. And that's effectively, what we're saying here is, if you look at the EU principles behind this and the general non-discriminatory principle, along with effectiveness and order, when it all comes into play, whilst you may say on a particular fact it's a complicated model to apply, A, we say that's the intention when I progress through my argument, hopefully I'll convince you of that, and B, that's what happens up and down the land anyway, with very similar drafted provisions. So in other words, is this, when you're looking at the comparison, the same opportunity as comparable or not? Because that's when we get to legislation later on after the comma, that's the key phrase, or we submit as the key phrase. But I appreciate, just on the strict or simple terms of the words, it's not apparent. Fundamentally, though, we say that's not how you read the legislation because of all the background and context. My Lords, I'm going to return to my outset observation, which is possibly no longer at the outset, but...
We've almost covered the case already, Mr. Kane.
In effect, the respondent is saying, similar to your Lordship's point, that in fact the directive, I guess the agency worker regulations, contain too few words to be what we say. And we submit actually the contrary. But actually, if you look at it, it contains too many words to be simply a right to be informed. So actually, there is obviously a conflict in statutory interpretation, to be blunt about it. There's always going to be points in their favour and points in our favour. But key to interpreting this is what is the purpose. And, as we'll progress to show later, hopefully, this consequentialist approach. In other words, if you accept our argument, actually all the supposed issues with it on a policy type level can be met. Whereas, if you accept their argument, effectively the right is neutered. There's nothing to it. It can be achieved by just an information, which is what happened, we submit, before the regulations and directive even came into force. That's what I'm going to deal with the modern practice argument.
At some point,
yes.
I know we're peppering you with questions before you've even opened the case, but such is life. Do you say it's a zero utility or just limited utility? Because the tribunal, the EAT, found there was a limited utility to a right to be notified. It wasn't a great right, but there was something in it.
We say that in fact it can be zero utility. And the reason I say that is because if the right is simply to be informed, and I'll take you through these facts because they're pertinent, which is this: we only have to inform you, that's the only right, and we only inform you at the same time by a general announcement, but we will tell you in the same breath that you cannot apply. The only time you can apply is when it's an external post. Now, to state the obvious, an external advertisement is going to everybody. The whole purpose is to get people to know about it and apply. So actually, you're allowing a right to compare themselves, and when we say the proper comparison, which with respect to the respondent, we say is not applying, is with those in the workforce. In other words, the internal people, in this case, what they were called reserve OPGs. So they have to be put in that position. Otherwise, effectively, we get to the utility argument, which is all we need to do is make no changes whatsoever. I make sure as an employer I do one of the following. Either I put a general announcement up and even have the statement, no agency workers need apply, or I even just send a circular email or an intranet. I don't change any of my practices. I don't have to ever let them apply for internal posts. So there's nothing gained from being informed. And more to that, I could even go so far as saying when it's an external advertisement, it's external, everyone's informed because it's external. I'm not even going to bother telling people. And I know this might seem surprising, but most employment practice, I suggest, is you often start internal, and then when you can't find anyone internal, they go external. So they don't necessarily repeat the same point again, saying, by the way, we couldn't fill the vacancy, because they've already told them that. That's just a point on the ground, as it were. It's not a point from necessarily this particular case, but that's the argument. So if it's applied strictly...
Is there any statutory right of ordinary, permanent, direct employees of a company to be informed of, let alone to apply for a vacancy? I don't think there is there?
No, unless you're dealing with potentially 2P consultation. You might say they're consulting about potential changes. The potential changes might lead to vacancies and restructures. But ordinarily, no. However, having said that, obviously you have the discrimination statutes and so on that apply. So if you were to tell one candidate in the year, we're going to have a vacancy, then assuming someone finds out about that, there would be potentially a breach of equality rights. But potentially, it obviously depends on the facts and the reason why. I guess in theory, in that same scenario, you might have a redundancy case where even absent any discrimination, they might say, well, the redundancy is unfair because you whispered about this to other people, or you told them on the sly. You didn't tell the other employee, and now they're made redundant. So answering your question bluntly, one, I know not of any statutory right, that is, it says so expressly in the legislation, but B, from particular facts, there may be one that arises. Now, obviously, my learned friend, when he rises, may disagree with my A, but that's to the best of my knowledge. So, returning to where we were, the reason is that the appellant's interpretation, which was the one favoured by the Employment Tribunal, not the ET, obviously, otherwise I wouldn't be appealing, is correct because of the underlying purpose. And what is submitted is that in its full consequences, and when the consequences are tested, so that is having regard to what we call effet utile, so the effectiveness type principle, or alternatively a consequentialist type approach, you can see that, or we submit, one should see that the appellant's interpretation is correct. And all the objections, as I've already stated before, in Coles or by the AT, can actually readily be met. So effectively a straw man's being built, saying this is going to make a huge change when we submit it. In terms of the outline, I will deal very briefly with the facts, then turn to the law also very briefly, and spend the majority of my time dealing with the four strands of argument, because we submit, when you look at those strands, collectively, it favours our interpretation. Now, the facts aren't in dispute, but I do need to deal with them, because actually they answer, I think, already some of the points raised by your lordships. And somewhat unusually, to focus on the text, I will ask your lordships to turn to page 18 of the authorities bundle, because I think it's useful when we're considering the facts in this case to look at the particular statutory instrument. So it's 13.1. So with that hopefully to the side, the bare facts of these, and these are the pertinent ones. Mr. Kocur is an agency worker. Obviously, there's no dispute about that, and he was during his assignment at the relevant time. The first paragraph to refer to, your lordships, is at page 158 in the core bundle. So one will see that the facts at paragraph 77 there, that they put on their notice board internal vacancies. They made clear who could apply, which didn't apply to the agency workers. And then moving on, the good measure at paragraph 79, the tribunal concludes that not only were they ineligible to apply, they were told of this. The next pertinent fact is at paragraph 81, where the tribunal conclude that, it's after the comma, can only apply, so this is agency workers, can only apply for vacancies which are advertised externally, and when they do so, they are in competition with external applicants. So the whole purpose of an internal vacancy list to them is moot. Looking at the regulations now, where we are with those facts, it states, obviously, an agency worker has during an assignment, pausing there, there's no dispute there, he's an agency worker, it's during an assignment, the right to be informed by the hirer of any relevant vacant post with the hirer. Obviously, the right's an issue in this appeal, but in terms of being informed, at its bare they were informed, we say not enough because of the later part. But the tribunal specifically found that these were irrelevant vacant posts. I'm going to come back to this because the statute, the instrument, already requires a comparison. It's not just information of any vacant posts, which we submit would be pertinent if the whole point was just to provide information, let people know even if you're going to not be able to apply, but relevant vacant posts. It continues to give the agency worker the same opportunity as comparable worker to find permanent employment with the hirer. Now, in this particular case, they specifically found as a fact, and it's not challenged, that the comparable worker was the reserve OPG, those being the people that could apply and that could be considered. So, on the facts of this case, you can see that we have a situation where, applying this, the agency worker is informed by the hirer of a supposedly, this is my inflection here, it's obviously not in the statutory instrument, but a relevant vacant post. I'm going to come back to why that's pertinent for us. To give that agency worker the same opportunity as a comparable worker to find permanent employment.
Can you just help me on this point on the facts? What was the duration of Mr. Kocur's assignment?
It wasn't found on any of the facts. He had been working, I believe, for circa 4 years, but I'm not sure whether there is any finding about how long the particular assignment was. And I suspect the reason for that is because these are what we call day one rights.
Yes.
So I believe, now, sorry.
Part of the issue in the case involved Article 5 rights, and he only would have got those if he'd been on an assignment for 12 continuous weeks. So he must have had
he had at least 12 weeks, but that because there have been several cases involving these parties, that was never an issue. Because even in the 20...
No, I understand that. It's not a question of whether it was 1 year or 2 years, but assignment of agency workers. The answer may be behind you, Mr. Caden.
Yeah. So, sorry, Muddle, can I just come back just to see?
Yes, you can.
Sorry, my lord, for interrupting. Do you want me just to give you the short factual answer?
Yes.
The short factual answer is apparently it's assignment by assignment, it's shift by shift. So Mr. Kocur's understanding is each shift he works, they count it as an assignment.
Yes. But that makes it makes 13.1 rather difficult to interpret. Suppose that somebody is taken on by a company as a temp, but the individual is not employed by the receiving company, but by an agency. So he or she is an agency worker, but the duration of the assignment to the hirer is, say, 4 weeks. The Article 13.1 right is to be informed, and you say to apply for and be considered for any vacancy which arises during those 4 weeks. But if the 4 weeks come to an end, the temp goes elsewhere, a vacancy occurs the following month, too bad, no right to apply. Then if he or she goes back for another month, 3 months later, again, it's a question of what happens during that assignment.
Yes, the answer, I think, to this is that obviously it has to apply to several different factual permutations, and the answer must be, we submit that all they want to make sure is that these are agency workers that are still, for want of a better word, at work. Because otherwise you'd have these books that are so great that someone will say, well, why didn't you inform me of this? And the sub-answer to that is the generous way it's interpreted in both the regulations and the directive. If one looks at over the page at page 19, they may inform the agency worker by a general announcement at a suitable place in the highest establishment. So what this means would be, even in your example of someone coming and going, the general announcement is there. As soon as they're at work, they can see it. You get the bare information. We obviously say they have a right to apply, or if it's in an email circular or on an intranet. But the point is they want to ensure that hirers, such as the respondent in this case, that might have a huge agency workforce. Now, that's not obviously everyone. Some of them have long-term assignments, and it's remarkably obvious that there won't be a dispute about, you didn't inform me of this vacancy. So even though on the face of it, when you say, well, how does it work if it's a shift by shift in this extreme, or to give your lordship's example, a 4-week period, all one is concerned with is when there was a vacancy, when the role was open, was this person an agency worker at some stage? And I don't think, we submit, it doesn't require anything more than that. So in practice, it's not that difficult to apply. In this particular case, say Mr. Kocur had gone off, I was going to say for a rival, but I'm not sure who the post office's rival is, but I'm sure there is one, and then finds out about a vacancy. He applies. On those facts, they may well say, actually, Mr. Kocur, you hadn't worked for 6 months. We've looked at the assignments. You weren't on assignment during any of this position of the vacancy. It's we are not obliged by virtue of the agency worker regulations because you don't qualify. Just the same as day 1 right or 12-week right. It's all baked in. There isn't a particular issue we submit on our interpretation with the fact that it says during an assignment. All it's trying to caveat or protect is if you have a large agency workforce, do you have to be able to, on our case, accept applications from everybody, even when they've had little to do with you? Now, obviously, on a factual matrix, and we say actually ours, but in many cases, someone's been working alongside a normal employment status person for possibly years, and that might even be an assignment.
Yes, well, I quite understand that, but in the hypothetical I was putting to you, which is quite common, perhaps not in Royal Mail, it's rather hit and miss that if temps, to use the old-fashioned abbreviation, if temps come and go for 2, 3, 4 weeks at a time, and the vacancy occurs on January the 20th, it's rather a matter of happenstance which temps happen to be in the building, so to speak, on January the 20th.
Yes, it is a matter of happenstance. However, when we go back to where we started with your lordship's question about what about criteria and various different things, let's take that extreme example. If they're just coming and going type temps, one assumes the vacancy that they would be applying for would have relatively low criteria. In other words, you don't need particular length of service and skills and all the things that would otherwise debar. Otherwise, even if it's happenstance, it makes no difference because the criteria will disqualify them. But that is life when you apply for a job. There is a matter of happenstance. Were you around at the right place when you saw a job or not? And all we're submitting is that's all it requires. If you're there, if you're available, if you are working alongside your colleague who has a different status, you both see the post, you're allowed to apply. I mean...
Okay, right. Sorry, now I interrupted you. You were about to go on to something else.
Yes, sorry, I was just going to return to hopefully conclude with the facts applying to this particular statutory instrument. So on the present facts, he's informed of a vacancy that he can't apply for. He can only apply for the external vacancies. And the EAT and the respondent, and in fact your lordship posited, there being some advantage or use of being informed, simpliciter, just informed. Yet obviously that's not the case in our particular case. And we submit that in fact it's ripe for abuse and can be effectively a nil or nugatory right if you just make sure you do the following, which is what Royal Mail do, make sure that you just post your advertisements in a publicly viewable place, whether that's the intranet, whether that's an email, or whatever. You don't need to do any more. And you can specifically say, for all these internal advertisements, no agency workers apply. Obviously, this is particularly extreme because the tribunal say that they were told of this, which I assume means told when they wanted to apply, that no, this doesn't apply to you. So on these facts, if you look back to the Regulation 13, they are not given the same opportunity as a comparable worker to find permanent employment. It's not the same opportunity because they're informed of something that they can do nothing with as their comparable worker. So in effect, what's being posited by the EAT and the respondent is no change to everyday industrial practice, no change to law, because it's pretty common for internal vacancies to just post it on the internal site or the board. It's very unusual to just tell one applicant by themselves that there's going to be a vacancy and not tell anyone else, because obviously that would lead to complaints within the workforce and alleged discrimination claims and so on. Sorry.
Those happen to be the facts of this case, and you may be right that they may be the facts in practice of many workplace situations. But we're not dealing with that as such. We're dealing with what is the correct interpretation of Regulation 13. And the correct interpretation must be the correct interpretation in all cases. And so just suppose, you may say it's a fanciful hypothesis, but just suppose the employer doesn't mind. When it comes to the selection criteria, the employer is perfectly willing to consider the agency worker, the temp, as my lord calls them. The fact that they do happen to be in the building during that week, and therefore have the right to be informed of the vacancy, might be said to be something of value to that person. As my lord says, if they had been working there last week, but they're not working there now, they don't even have the right to be informed, because it's not during an assignment. So why do you say that as a matter of statutory interpretation, the right is rendered nugatory?
Because of its potential. Because the point is, whilst you say there might be particular facts where they might not care, the response to that would be, well, these are facts that you wouldn't even need to rely upon the regulations for. You have there this very...
No, forgive me, you would, because, as my lord has observed, that the one who was working there previously, but isn't there now, because it's not during an assignment, they don't have the right to be informed. It's only the one who happens to be there now who has the right to be informed. So it may not be of great value, but it might be said that it's of some value and gives them something that other people don't have in society.
But only when you add that extra context, which is they don't mind if you apply.
Yes, but don't you have to assume that at least is a possible hypothesis, because we're interpreting the legislation generally, not tailored to the facts of this or any other case.
Yes, but that's the nature of consequentialist interpretations. In taking your example, you can apply it to these consequences, which is, I'm going to call them the charitable hirer, for want of better words, apologies. And you will see the result could be of some value, but then you apply it to the other extreme and you see this other result. And that's why you're saying, well, objectively we interpret this. This has to apply to every case. And when we say you apply it to every case, it means when looking at the less charitable, for want of a better word, hirer, you get these bizarre results. And we go so far as saying, effectively, it adds a base level of nothing. Because all you get to is a position where your lordship is saying, this particular hirer doesn't mind. And that doesn't require the regulations at all. That requires just a hirer to put an advertisement, the happenstance that you mentioned, my lordship, someone seeing the advertisement, them applying, and them saying, well, we don't mind that they're an agency worker. They seem a good, I was going to use the word fit, but that was a poor in discrimination terms to use that. They seem like they meet the criteria. So that is something that's just, there's no need to legislate for, with respect.
Can I ask you this? The directive is an instrument of minimum harmonisation, which comes from Article 9. And it seems clear from the recitals to the directive and the travaux préparatoire that the instrument, it took over 20 years of negotiation, including detailed negotiations between the unions and employer representatives. And they didn't find it easy, not least according to the recitals and the travaux, because even the unions couldn't work out who the comparables were and what the correct relationship between permanent and temporary employees were. So you're left with a situation that Article 6 sets out somewhat of a rag bag of individual rights. It's by no means complete, but it reflected the compromise which was reached after some 20 years of negotiation and embodied in 2008 in the directive. And don't we just simply have to accept that it is what it is, a series of quite random pieces of variable geometry? You're trying to get us to expand, as you properly and fairly accept, on the literal wording of Article 6 and Regulation 13 beyond the right to be notified. When you look at it, and your argument assumes you're picking on the illogicalities, but isn't that just the net effect of 20 years worth of negotiation, a stalemate, and a recitation of where they've got to, which is what you find in Article 6. It's a fairly random piece, selection of rights. It's a million miles away from being complete or logical. It's not a complete jigsaw, it's just bits of a jigsaw. What right do we have to expand upon those rights?
Well,
Member State could have done. The UK could have gone a lot further and accorded the rights in Regulation 13 that you've asked for, being entirely logical for them to do so. They were entitled to do so. But on the face of it, they didn't.
so the response to that is, firstly, whilst there was obviously debate, and we can refer to them as a rag bag of rights, if you go through the recitals, in fact, I'll deal with that point now, I'll go through the recitals to show how it influences. So that's the first point. We don't accept the general proposition. And that's also infused with the general principles of non-discrimination, the general things that, irrespective of a directive, this is what the EU body of case law stands for. So that's the first point. The second point is, actually, the agency worker regulations do go, if you're not with us on that point, go a little bit further with their drafting. They don't completely lift. So one example is, they have an initial comparator approach. So when we go to the regulations, you will see that it's just informing of a vacancy, not a relevant vacancy.
Article 6 doesn't have the
Yes.
word relevant, and Regulation 13 does.
And then secondly, it also has an extra comparator branch, because then you have to compare yourself to the comparable worker, which it isn't there. So those are the headline responses to your question. I'm going to take you to the recital now to deal with the detail, and I will come back to one aspect of the law later on. If one turns,
Can we look at Article 6 before we look at the recital?
of course,
Because you say that Regulation 13 should be interpreted in the light of Article 6, that it was introduced to give effect to Article 6. If you're right, Article 6 is expressed in very wide terms that temporary agency workers shall be informed of any vacant posts in the user undertaking, to give them the same opportunity as other workers in the undertaking. It's not relevant posts, it's not posts for which they're qualified, it's any vacant post. On the face of it, that's enormously wide.
yes. However, the reason is, when we go back to the recitals, because of the overarching aims and the integration, and what we submit is the general preferred contract. But also, even if it's very wide, let's say that someone were to complain, for argument's sake, a agency cleaner complains that they weren't informed of the vacancy for the senior engineering post. With respect, where does it get them? What's really the loss? I mean, they can say, you should have informed me.
Well, maybe, but the logic of what you're saying is that the regulations very largely fail to implement what you say is the right. I mean, most people would say the example you've given shows that such a right would be rather absurd if the post of senior engineer in Royal Mail or chairman of the company board or something comes up. It would be rather extraordinary if the EU legislation was saying that vacancy must be notified to a cleaner who's there for 3 weeks. But I think that's what you're saying that Article 6(1) requires.
Well, we don't go so far because we say it may say that. And the reason I don't go so far is because it's clear what the regulations say. And I'm not having to show, in this particular case, that the regulations, in terms of Regulation 13, are in complete breach. So I'm not saying that. It may well be another council, they argues that, without wanting to detract from that future potential argument. What we would point out is that if you look at Article 6, it says to give them the same opportunity as other workers in that undertaking to find permanent employment. And that phrase may be taken to be interpreted as the same opportunity as other workers means that there is some kind of comparison, and that other worker has to have some kind of comparison. And given it is to find permanent employment, we interpret those words to get a job, and it may well be put forward that actually there is no breach in terms of the regulations, because they'll say, well, in this extreme example, they don't need to be informed of the CEO role, I can't remember what it was, because that's not as other workers in that undertaking to get them that job.
Because the cleaner wouldn't be given that opportunity anyway.
Yes, exactly.
So it's not the status of being an agency worker which is being held against you. That's your fundamental point. It's the fact that you're obviously not suited to apply for the role of CEO.
Yes. Not in our case, but in the case posited by.
And you say that the word "to give them the same opportunity," etc., must be given some meaning and effect, because otherwise this could simply have stopped. Shall be informed of any vacant posts in the user undertaking.
Absolutely. But that's it. If it's pure information, that's all that would be required, and the regulations would have done likewise. And we see that also from the fact that it says at the top, access to employment. And the reason I say that is because, having regard to all the rights, we have the directives dealing with what we have going to call affectionately, what some people know as TUPE, which is just information. That's the heading. So they're quite happy, the EU, to write directives with just information rights. But this is access to, and when you look at some of these rights, which I accept are of varying different natures, you can see some, in terms of 4, are certainly substantive, because it's the collective amenities and everything. So it can't be suggested that Article 6 as a whole, I mean, we say obviously it all influences when you read it all in context. But one suggestion by the AT and by the respondent is this should be in Article 5. And our answer is no, because if you look at the heading and the rights in general, they are concerned with substantive rights, as opposed to just information rights, which obviously...
Is there any... Sorry, had you finished that?
Yes, I had.
Just going back to the wording of Article 6(1, on your submission, is there any significance to be attached to the fact that the phrase used is to give them the same opportunity? The wording is not to give them the opportunity. So do you say that the word same implicitly introduces some kind of comparison?
Yes. We do. And that's obviously clearer in the agency worker regulations because they actually use the word comparison. But in terms of just linguistically, yes, we do say that.
Yes, you're right. That does say a comparable word.
So you say there's no real inconsistency between Article 6 and Article 13, at least so far as the addition in Regulation 13 of a comparability requirement. You say it's implicit in Article 6.
It's implicit, but the fact that they make it explicit shows that the government, Parliament, are deciding to legislate in this way. And you can see that when you read the rest of the requirements of the regulation, because they're quite clear in terms of, sorry, we've been darting around, so we've probably moved on from the regulation. But whilst you raise the point, you can see at page 18 of the authorities bundle, 13.2 gives very detailed comparison, and it continues with, if you cease to be employed, you're not a comparator. So, for want of a better word, our legislator picked up the baton and said, well, we don't want a dispute about exactly what the comparator is going to require. So yes, we say it's consistent. And that's just the nature, as you'll appreciate from your previous practice of EU law.
A point was taken by the EAT, by Mr. Justice Cavanagh, about the difference between the breadth of Article 6 and Regulation 13. So your argument is, well, if you read Article 16 excessively literally, that might be true, but actually logic and indeed the reference to equality in the recitals means that they are really consistent.
Yes.
Now, I apologise for having diverted you. You were about to introduce us to the recitals, to the directives. Would you like to go there next?
Thank you, my lord. The relevant ones we submit start on page 2 of the authorities manual. And recital 11, which is relied upon by both the AT and in particular my learned friends. Temporary agency workers meet not only the undertaking's need for flexibility, but also the need to reconcile their private lives, thus contributes to job creation and participation in integration. Now the AT and respondent sees upon that by saying, well, this shows that what's concerned with is flexibility. But what we are arguing for doesn't stop flexibility in terms of the use of the agency model, which is the point of this. What they want to do is say, us legislating in this area doesn't stop you using agency workers in the way that you want. And our submissions don't detract from that. What we have is a vacancy where they want to give it to an employee. That's the whole point. The fact that it might be an agency worker that applies and gets that doesn't stop them using their agency model. They just potentially recruit another agency worker to fill that void. And in fact, we go further because we say, when we look at terms of the job creation and the other mentions of the recitals, it actually is furthering the implicit EU aim, which is job creation, and the fact that the fact that if we skip forward to recital 15, employment contracts of an infinite duration are the general form of employment relationship. Now, it's accepted, going back to your lordship's point, that there was obviously a difficulty getting this over the line, as it were, and which is why they've got a series of compromises. But the recitals is clear that that's the general form of relationship. So why shouldn't that be encouraged? By encourage, we're not changing, once we say, the use of the agency model or the vacancy. All we're saying is you have to give the comparator, the agency worker, a fair chance to find permanent employment. To be blunt, we're going to submit very shortly that to find permanent employment just means to get a job. Mixing the areas of my argument in terms of, I was going to get to that point later, but I will return to it. Whilst we're on page 2, the next recital that we say is of some relevance is recital 12. This directive establishes a protective framework for temporary agency workers which is non-discriminatory, transparent and proportionate, whilst respecting the diversity of the labour markets and industrial relations. And our simple submission is, our reading of the right is completely consistent with that. It's protective. It's to stop non-discrimination, because the only ground is status. I'm repeating that criteria is absolutely acceptable. The redundancy argument we have a response to. We're not stopping them. It may well be that my client applies and he's just not the best candidate. That's fine. It may well be he applies for apparently a comparable worker post, and for some reason their criteria requires a particular examination that for some reason they're not so worried that the agency workers don't have. He doesn't get it. That's fine. But what is not allowable is you're an agency worker, so apologies, you can't apply.
Can you exclude someone in advance in the vacancy notification on the basis that they have not served within the hire for, let us say, 2 years?
You could, and it wouldn't be a breach, because all you're doing is you're just setting out what the criteria is in the advertisement. Now, obviously, the agency worker can apply and they can get immediately knocked back because they don't
apply. Can they be blocked, therefore, from applying? If it says you must, to be appointed, you will need to prove that you've been employed for a minimum of 2 years. Next, if you have not been employed for 2 years, you should not apply, or you may not apply.
The reason I'm grimacing is it's really a matter of semantics, because if they apply, then they'll just be knocked back.
Well, exactly. So the logic would suggest that you can prevent people from applying. There's no point in allowing someone to get dressed up, but then barring them from the party when they get to the door.
There's no point, but in terms of just reading the regulations that we're dealing with, you have informed them of it. When I say that they have to be, that gets the comparator point, because then the comparator, I guess, would be someone that also has, as long as you were to treat, this is semantics here, but as long as you were to treat the employment status person or non-agency worker who hadn't got 2 years the same way, in other words, you wouldn't even bother looking at their application, and you would say there's no point of applying, then there'd be no problem with our argument, because the comparator has been treated the same.
But logic would suggest you can also say you cannot apply because you cannot meet the selection criteria. What would be the point of saying you can apply, but we will weed you out of the first sift? What's the point?
There is no point. So, yes, that could still be consistent, but my point is, it is still semantics. As long as you treat the non-agency worker the same way, that's all. And the only reason for that logic is because that's how the words are on the page, and that's what makes sense.
Does your submission, I don't want to put words in your mouth at all, I want to understand what your submission is, but does your submission really come down to this proposition, that the employer is still free to have any selection criteria they wish to, as long as they don't deploy the criterion of being an agency worker?
Yes.
To knock you out. So, for example, if the criteria is that you have to be sufficiently senior and experienced and able to do the job of CEO of Royal Mail, obviously the cleaner need not apply. But that's because they're not qualified to do the job, not because some can apply who are permanent employees and others need not apply because they are agency workers. Is that at its core your submission?
Yes. But that is at its core my submission. To presuppose or apply, what we would also reject is you can't use criteria that is, by its nature, implicitly employment related. So length of service is fine, as long as it's just the amount of work you've done for us. If you were to say you can only apply if you've had 3 years employment service, then I would also take objection, because effectively all you're doing is just trying to move the target. But yes.
Because in theory, again, one is always dealing with hypotheticals, because that's the way you test what is the correct legal answer. So if the employer advertises and says there's a minimum length of service requirement of 2 years or 3 years, whatever it is, what they're doing in a sense is that they're disabling themselves from being able to offer the job to a permanent employee who's been there for 18 months. If they're happy to do that, fine. But your fundamental submission is what you can't do is say the reason why you're going to be rejected is because you're an agency worker.
Yes.
I'm not saying that's right.
I know you're not saying that's right. I'm hoping you're going to allow me to continue to develop that, so to hopefully convince you of its submission. But yes, that is the fundamental submission.
So in your submissions, I want you to address this. If that's your bare minimum, if you were the legislative draft person, I mean, I accept it. I think we can all see that may make very good sense as a matter of policy. The question is it the law? So to draft that, there would have to be the right which was set out, which is a right to receive notification. You then have to have the right to apply. You would have to have a right for the employer to set out selection criteria. You would have to set out rules governing which selection criteria were acceptable and which were not. And you need some right, something specifying what the consequences were, that it was permissible for an employer to preclude people from applying if they didn't meet the selection criteria. That's what you're saying we have to, as it were, imply into Article 6 and Regulation 13. And That's quite a lot. Absolutely. I mean, we're obviously not debating the policy sense. There may be very good policy in that. That's a lot to imply into Article 6.
But you get that from page 18, Regulation 13.1, as they've drafted it in the UK. Because that is what comes after the comma. So if we start with the proposition of just deleting the bit after the comma, we get to effectively what the respondent is arguing for. Because the agency worker has during assignment a right to be informed by the hirer of any relevant vacant post with the hirer. But after the comma, there's to give that agency worker the same opportunity, and this gets back to Lord Justice Singh's point about, well, who's the comparison? If you want to preclude everybody with less than 2 years service, so be it. That's fine, because it says to find permanent employment with the hirer, and to find permanent employment with the hirer means to get a job with the hirer. And I'll deal with that now because I've mentioned it. There's two reasons for that. One reason is you go back to the EU, who use the same phraseology, but you get back to the French language, which uses a slightly different term, obtenir, l'emploi, and they have used other terminology, trouver emploi, elsewhere. And the second is just plain English. If I have a bad day today, and I tell my wife I need to go and find a job, she's not going to point me to the classifieds. She's going to say, you mean you need to get, you need to find employment, you need to get a job. You want to be an employee now, you're going to give up this barrister art. That's what it means. And so much so that if we go to the reasons, that's perhaps why they've rejected that, but also that's why they refer to BIS guidance at, it's at page 159. It's a very short point of the core bundle. Page 159. And it's the point being made at paragraphs 88 to 89 by the tribunal, first instance. We do not accept the respondent submissions. The right is to be given in form to give that agency worker the same opportunity. And they refer to the BIS guidance, making it clear that this won't apply to headcount freezes. There's no need for this concern in the government to have this, appreciate it hasn't got statutory force, but to be giving such guidance if all there is a bare right to be informed, because who cares? It's not going to cause an issue. It only causes an issue if there is also a right to be considered, applied, however we want to do the phraseology. So whilst we accept from a UK-centric approach, we would perhaps have many, many more layers, because that's the nature of drafting a statute. One, the EU didn't require that and is using effectively the same wording. And two, when we do use different wording, we've gone to the detailed comparison, we've used this wording, and this is effectively anti-discrimination wording. And in anti-discrimination wording, we don't have, by the way, this requires this, it requires this, it requires this. Because all you need to do is you just need to have that comparison and find what the reason why is. And that gets back to your point, my lord, which is, well, if the reason why is just status, agency status, you can't do that. If it's something else, then so be it. And that's when we get to, in recruitment terms, criteria.
Can we just approach the interpretation of Regulation 13.1 on conventional English law principles of interpretation? So let's forget for the moment that the origin of this is EU law. Just want to understand your submission. Are you submitting that if this were merely a right to be informed, then the draftsperson could have stopped where the semicolon is?
Sorry, mine's a comma, sir. But I think we're talking about...
Sorry, comma, yeah. It could just have stopped there. So the rest of the words are mere surplusage. If the respondent's submission were correct, and if the EAT's interpretation were correct, do you say that one could simply have stopped after the word the hirer?
Yes, which is why when I made the introductory remarks, I said they're saying we have too few words, we say you have too many.
Yes.
And that's it, and then the rest could go. And then you presupposing what my learned friend will say, they'll say, oh, but you have to be informed at the same time, you have to be informed but that can just be left to the same implicit arguments, which is, well, if someone has a right to be informed of a relevant vacant post, clearly that means when the relevant vacant post is alive, when it's actually a vacancy, when you can apply, as opposed to the vacancy is now gone. By the way, there was a vacant post 5 months ago.
If you did cross out the rest of 1, you'd have to cross out 2 and 3 as well.
Yes.
Because they all become redundant. So you'd just be left with, apart from 4, which is about the form of the announcement, all you would have is an agency worker has the right to be informed by the hirer of any relevant vacant posts. With the hirer,
Yes.
would be massive litigation on what does relevant mean, because you would have no clue at all. But anyway, that would be the effect of it.
That would be the effect, but we have massive litigation for that phrase and similar ones
Yes.
in all statutes.
Yes.
And that case law generally tries to express what it is. So yes, if we're just approaching this from a domestic point of view, that's what we submit.
My Lord's example earlier of the cleaner versus the CEO may be, if I may respectfully say, a helpful way of looking at many of these issues that arise this morning, because then it'll be said that the cleaner complains, I wasn't informed that the CEO post was vacant, and if it had arisen for interpretation, we might have said, well, hang on, that's not relevant to you. But your point fundamentally is, if it was simply a right to be informed, then why has the legislation used so many words when it could have used fewer?
Yes.
I'm not saying I accept that, but
Yes, I appreciate when counsel just give one-word answers. It seems like that's going to be the end, but I don't want to confuse matters. I'm not going to try to add nuance to it. Yes, that is the fundamental submission.
Your argument assumes that the EU law treats temporary and permanent lawyers as comparable, as alike. Is that justified on the basis of the directive, given what we know from the recitals and the travaux, that in fact what caused the negotiators more grief than almost anything else was trying to work out to what extent permanent and temporary employees were comparable? And Article 5, which qualifies equal treatment with comparability vis-à-vis basic rights, therefore not everything, and doesn't address the question pre-contract. It's concerned with post-contractual matters, the definition of what the basic rights are. It seemed, on one view at least, it's not implicit, at least it wasn't in 2008, that temporary employees were, in all respects, comparable to full-time employees. But again, they may be wrong now in 2022, it may be arguable, but that was the position which might be said to come out of the recitals.
We reject that, because what's happening is this. One, it's only this information aspect and right to apply where this comparison issue arises. In Article, by that what I mean is, Article 5, the difficulty was what particular conditions. If you have an agency worker working, are they going to be treated completely as if they were an employee? And that makes difficulties with the models. That anyone can see that. But in the Article 6, Article 6, I'm looking at the regulations. In the Article 6 issue at hand, one isn't changing the model, one isn't changing any terms and conditions, because this is what the hirer is offering. They've got the vacancy, they have their terms and conditions. So the only issue is it appropriate to inform, but then not really give them the same opportunity? In that undertaking to find permanent employment.
One shouldn't trivialise this directive. It seems to me Article 5 is the most important section, and it's rather significant. Without it, a member state could allow its employers to pay agency workers half of what permanent direct employees were paid, and so on. My Lord Justice Green described Article 6 as rather a ragbag. It seems to me that the heart of it is Article 5, and then there are some additional things in Article 6, and the question is what's the extent of the additional points?
Well, my Lord, we characterise it slightly differently. Article 5, yes, is the heart, but that's because that's the most difficult thing, because that's when you are trying to change the model and the way that the businesses want to operate. Article 6, I accept, obviously, there's the issue about being able to go to the canteen and so on, but in the broader sense, if you go to the préparatoire and so on, there isn't really a significant objection for the most part. And we submit there isn't principally a significant objection to our argument. In other words, why should it be the case that you can't consider that you can discriminate, our words, the agency worker, just preventing them from applying? And how does that work with the earlier bits of the recitals?
Is one way of comparing Articles 5 and 6 possibly this, that Article 5 is concerned with what the basic working and employment conditions must be of the agency worker once they are in post. And one of the topics covered by Article 6 is, according to the heading, access
Yes.
to employment. In other words, before you've been put in post. Because access to employment on your submission, again, I'm not saying I agree with it, but your submission is that the opportunity to apply for permanent employment is an example of access to employment.
Yes. However, I have to accept that that works for the majority of Article 6. It doesn't quite work for paragraph 4. Because it's access to the amenities. Now, obviously, it's the same word access, but clearly that means when you actually got it.
That's because the heading of Article 6 isn't confined to access
Yes,
to employment.
yes.
It also talks about collective facilities and vocational training.
Yes, that's our answer to it. But if one's just saying, if you look at Article 6, it's always before employment.
It was only taking the words access to employment, and I'm sure one has seen this in other contexts. It's not just. It can be that can be contrasted with what happens to you once you've been recruited. And so, for example, conceptually, the equality legislation obviously governs how an employee must be treated once in post, but it also has things to say about access to employment. So you can't be discriminated against when you're applying for employment. So I think your fundamental submission is that the whole of the principle of equal treatment is not necessarily captured by the terms of Article 5.
Yes, and we see that from the points that you make, but also the wording, because it's the same opportunity, which we say is an equal treatment wording, and even more so when we get to for the same conditions.
Why not, if you're the European legislator or drafts person, why not just have Article 6.1 beginning, temporary agency workers shall be given the same opportunity as other workers in the undertaking to apply for any vacant posts?
I can't explain why they decided to draft it that way around, but what we're saying is that you reach effectively what your lordship is doing is just flipping the sentence structure. That's what we would be saying. You might say it's an inelegant way of doing it, but that's the same as if we start to temporary agency workers to give them the same opportunity as workers in that undertaking to find permanent employment shall be informed, blah, 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 blah. And I submit that we get to it's not quite as elegant and as short as the way that you've phrased it, my lord. You get to the same result, you use the same words. All I've done is I've flipped the beginning and the end. The drafts people in this particular context didn't want to use a comma. We've chosen to use a comma, but I don't think there's any significance in that. Same words there, same sentence. All I'm doing is I'm just reordering it. But the reader, I accept, would read that and perhaps have a more charitable view of my submissions and think, oh, well, obviously that's the purpose because they put that at the beginning. But it's still there. But obviously I don't know why exactly. I haven't got an answer to why the EU drafts people decided to do it the way they did. But it's not inconsistent the way that the words that they've used in our argument is our fundamental response.
I think it's possibly because of what they say in Recital 9, where they identify the concept of flexicurity. And they talk about striking the balance between flexibility for the employer and security for the temporary worker and improving the quality. I mean, it all boils down to where they struck the balance. Whether it was a good striking or a bad striking is rather beside the point for us. It's where did they strike the balance? And you've made a powerful case for saying, as a matter of policy, they could have gone further if Roman is correct, the EAT is correct. But they say they just didn't. That's the issue for us. Where did they strike this balance? Not from our perspective, what would be a good balance or a bad balance. And they had to strike a balance between flexibility and security. What they call flexicurity. We simply have to look at the words and find out where they struck it. And you've got to persuade us that the recitals inevitably identify a gap which we have to plug by purposive construction. I'm not certain the recitals really take us very much further. They're just telling us there was a balance to be struck. It was a difficult balance, took them a very long period of time to strike it. And however inadequate it was, their solution was Article 6.1, a series of variable geometry, minimum harmonisation, member states may go further.
This comes back to one that's the nature of legislation in this regard anyway. There's always a proportionality principle anyway. So where they start adding flexicurity and there's always a balance. Now, we submit, the EU, just as you can as a court, apply those principles. And I'm calling them policy. I give it the name proportionality. I don't see an issue. And the other point to be made is there is a distinction between the balance in terms of affecting the model of agency, which is why we speak so much about Article 5 and the other parts. In other words, are the changes affecting the way that you have an agency worker? Are we going to have to pay them more? Can we pay them less? Can we give them other rights? Can we do this? Which is actually the majority. It's the security dealing with you as an agency worker. And this appeal is with a much narrower and smaller part, and we can see why, on our basis, they've spent less time on it, because, for proportionality reasons, it was obvious. What we want is, we're not changing the model. You can have agency workers, you can do what you want with agency workers, but if you have a vacancy, in terms of our proportionality, in terms of effectiveness, in terms with general non-discrimination, as far as the EU is concerned, we submit, they think it's obvious. You give them the right to be informed, to have that same opportunity. That must mean that you don't just say, we're going to give you a right on the one hand and be able to lawfully ignore it. The application, that is.
Mr. Cavan, can I take you, sorry, had you finished on that?
I had finished on that point, yes.
Just want to go back for a moment, if I may, to my Lord Justice Bean's question about the order of the way in which Article 6.1 is drafted. That was a point that Mr. Justice Langstaff made also in Coles. So I don't want to take you out of turn. If you're going to show us Coles later, then I can come back to my question about it. Do you mind if I go to Coles now?
We may as well go to Coles now.
Page 32 of the authorities. Paragraph 34 in that judgment. Do you have that?
I will momentarily.
Tab 3.
Yes.
Paragraph 34, as I understand it, was really making the point about order of wording in Article 6.1, which my Lord has also put to you. And I just wanted to ask you whether you submit that paragraph 34 in the reasoning of Mr. Justice Langstaff was wrong.
Yes. And the reason it's wrong is twofold. One is for the reason that I've already expressed, that you change the order, you get the same result. You're not changing anything with the words. There's no principle, as far as I'm aware, in terms of EU drafting that suggests the beginning of it has to be the important part, and then it goes down. They're not trained in the journalistic school of, you start with your headline, then it gets less and less important as it goes down. And the second point is he places great reliance on designed. This is after the comma, the penultimate sentence, towards helping to find it. So my reading of the learned Mr. Justice Langstaff is that he's placing great reliance on the fact that the legislation has chosen the word to find permanent employment, and for the reasons I already submitted, I think that's misplaced.
I'm not sure that's necessarily right. I think that the contrast is between securing it and helping. So and it might be said that a right of information does help, because others who were there 6 months ago but are not here on an assignment now will not be informed.
But only if they can apply.
I understand that. That's going back to everything we discussed earlier today. I don't want to go over that again. All I'm saying is that a right of information, what is being said here is that the order does matter, that the only right Article 6 creates is the right to be informed. The purpose of that is then spelt out in the ensuing words. And therefore, it's not that there are two rights created. There's only one right created, that's the right to be informed. Why? The remaining words tell you the purpose, why this right of information is being created, and it's designed towards helping you to find employment.
We still submit it's wrong, and we submit that's too narrow reading because, for example, it doesn't consider the fact that it starts with access to employment. There's no explanation of that particular heading. We get back to the recitals and so on. So this is placing great stress on the order, and we fundamentally don't accept that is the result.
It isn't simply the order, though. It's the content as well. Of course, if Article 6 had used exactly the same words simply in a different order, then that wouldn't be any different. It's that it doesn't use the phrase the right to be given the same opportunity to find permanent employment. Not Article 6, Regulation 13. That it could have said, but does not say, an agency worker has, during an assignment, the right to be given the same opportunity as a comparable worker to find permanent employment. If that's what it had said, then the details of how the information should be conveyed wouldn't matter a bit. That would simply be a small part of the right to apply, and only a small part, and with no details being given about anything else of how the right to apply is to be exercised and how it's to be considered by the employer. That's the point. It isn't simply a question of the order in which words are used.
But the response to that, given you mentioned the regulations, is the latter part after the comment says to give. So clearly the purpose of giving the information is that, in ordinary language. And how can it be the case that you can inform someone and not allow them to go any further, and that be said to give you the same opportunity? So it's still incorrect. And whilst we're on Coles, I think it's important that we look at paragraph 35, because one will see that this is the third sentence. Well, the point being raised is effectively in this case. The second sentence, the solemn farce would follow that such a worker would have to be told of the vacancy, but as soon as they asked details, they would be told the post was not available to them because of their status. Though that point is raised forensically, I think its central weakness is its lack of reality. If an employer has an additional job of over and above the current field with its undertaking, there's no obvious reason why the employer would wish to turn down the opportunity of having an employee suitably qualified and able to do the job. So, obviously, it's a difficult task, being a tribunal, being a court. You're looking at things through a particular factual lens, but one of the key factors appears to be that this present case seemed to be something that would never happen. Why would you need to say that? And we submit that's incorrect, because this has happened with a large employer. But also, this particular case, Coles, is dealing with a different argument, because Coles is dealing with, if we turn back to page 30, and it's paragraphs 13 and 14, it is held that regulations and directives both permitted an employer to give priority to workers whose posts were redundant or at risk. And it continues at 14. It made the point that directive does not require the employer to displace permanent workers. And then you move on to their discussion of this at paragraphs 22 and 23. During oral argument, Mr. Leach accepted the fundamental argument he was making was that an employer has no right, when selecting whom to appoint, to give to a vacancy, to give priority to existing permanent employees who, because they were otherwise threatened with dismissal by reason of redundancy, had been placed in a redeployment pool. And it continues at 23 and 24. So central to that case, as the argument was being made, was that you can't apply this criteria. The agency worker has an equal right to go for this post. And you can see in that context why you have all the objections. You can see in that context when they respond to counsel saying, well, you raised forensically this novel point, that's clearly not what's happening. Why you get to the position which Coles get to. And this emphasis of paragraph 34, and it has to be read with the other part of the ratio, paragraph 37, which is I accept there's no basis in principle for protecting a job of a temporary agency worker. That's not what's being submitted in this case. That's why Coles is a very different case and led to that result, and we submit the same result can be reached in that case with our interpretation, because this goes to the criteria, and it's fine to say, well, preference is first given to those who are going to be made redundant. And that also explains why, reinforcing the point, when you go to the tribunal that accepted initially Mr. Kocur's argument, they refer to the BIS guidance, because they're pointing out the head can't freeze wording. In other words, saying to employers, do not worry, this isn't going to mean that you have to now have a problem with redundancies. That may well be even why in previous iterations of the case that the concession was that there was a breach of this regulation. It's only later on down the line that this is now being taken. So it is wrong in terms of its emphasis on the order of the words and why it must be that all they're seeking is a right to be informed, because actually that gets one nowhere if you apply simpliciter and strictly, which is what the respondent is inviting the court to do.
I think while we have Coles open, certainly I still do, it's only paragraphs 34 and 37 that were sidelined, but in fact the whole of 32 to 37 is rather important, and Mr. Justice Langstaff puts in paragraph 33 rather better than I was doing. The point about the content of Article 6.1. It is paragraph 34 is about the order of the words, fine, but there's also the point he makes about paragraph 33. Let's have a look at that.
And the answer to this, as far as we're concerned, ignoring obviously that went out the Court of Appeal stage, is it's still focused, if you look at the last sentence with eligibility on an equal basis with those who are in a redeployment pool. It's still obsessed with the issue of that being the comparator, which it isn't on our reading. No. So, yes, the point's made, and you've already eloquently put various of these points. That's based on the reading of Article 6.1. We put forward why that can't be read in isolation. It has to consider not just the heading, which has been looked at, but the recitals. In fact, I just have to go to see whether I missed any of the recitals off. But also the general principles of effectiveness, proportionality, of non-discrimination. This case, fundamentally, wasn't discriminatory. Because that's the point. Other people in the hirer's workforce also were in the same position. And one assumes they would also have been comparators with the agency worker. The agency worker saying, I want this particular post, and I'm a suitable comparator also. My lords, was there anything else on Coles?
No, I don't think so.
So just rounding off the point in terms of Coles, the mention there, you rightly point out paragraphs 32 onwards, is that effectively the provision of information is to satisfy giving it at the same time, in the same form, and so on. Now, we submit, well, obviously, because they have a right to apply. Otherwise, why does it matter whether you're given it at the same time? At the same time so that you have an equal opportunity to apply. Why does it matter that you're given it in the same form, that there aren't certain criteria that you're not shown? Obviously, it's all implicitly because you also have the opportunity to apply. Otherwise, what's really being achieved, we're just saying all this requires is information, and we need to make sure that all the information is provided in the same manner, when at the same time one can say, but you can't apply. And fundamentally, our explanation for Coles is that's because they were concerned with this redeployment pool and with the submission being put forward, which was this person has to be considered for that vacancy, and that might lead to this other person losing their job, which is not our situation, and is not the interpretation that we're asking or inviting the court to accept. So returning to So one point to be made about the directive that I haven't yet made is after recitals there's the aim, and this is at page 3. Article 2, the aim, the purpose of this directive is to ensure the protection of temporary agency workers and to improve the quality of temporary agency work by ensuring the principle of equal treatment is applied and so on. And what we submit is with that and with the recitals, one of the ways of achieving that protection, achieving the integration, achieving so on, is to give them a right to change their status. They don't get it as a matter of fact, but they have to be in with a chance. Change status as in go from an agency worker to an employee if they get this job that's an employee job. In terms of I've dealt with the directive, and I believe I've already dealt with the agency worker regulations in many of the arguments that I was hoping to raise. Just to reiterate before going on to briefly consider one domestic authority. If one returns to the agency worker regulations, which are at page 18, and this also, I guess, is an answer in part to Coles, which is Coles only considers the first paragraph and says, well, the order is very important. What we say that they don't consider is, one, the fact that it has any relevant vacant posts, so the comparator point initially made, the fact that it then has the same opportunity as a comparable worker to find permanent employment. So we've got another comparator approach, which isn't needed if Mr. Justice Langstaff's argument is right and that's all that's required, just information. And then you've got the detailed comparator provisions. So why is there this? Why is there all this obsession and this need to provide all this detail for comparison? If you get to Mr. Justice Langstaff's point, which is, well, it's just about the order in that first paragraph, that shows you all you need is information. The answer back is, well, if that was the AWR draftsman's belief, why did they keep drafting? They could just leave it with the bit before the comma. You still get this same result.
I'm not being critical of Mr. Justice Langstaff in paragraph 34, but when he uses the word order, that might not be quite what he intended to use, because what he then goes on to describe is not order but substance.
Yes, apologies. But that substance that he's considering isn't considering, because assuming it wasn't put forward, and that's fine, because that wasn't that case. He wasn't considering the arguments that we're putting forward in terms of looking at the substance. It has the first detailed comparison. It then has the same opportunity, and we stress that opportunity has to be given some kind of relevance and meaning. And informing someone of a post but saying that they can't apply is not the same opportunity. Just linguistically, it's not. And he's not considering those aspects. And he's assumed that to find permanent employment is looking centric in terms of it just means you have to be aware of your availability, look at the classifiers, as it were, just the information. To get to our example that we returned to earlier, the cleaner and the CEO, effectively it doesn't matter, just provide the information. Obviously they're going to be discounted, that would be fine on the Coles reading, because that's all that's required, information. And we say, well, yes, but actually, reading the rest, that cleaner is not actually someone who is applying for a relevant vacant post with the CEO, and they're being given the same opportunity as a comparable worker in the alternative, because, well, they aren't actually, because a comparable worker would probably be equivalent CEO type people, I guess the CFO in this organisation. So it still hangs. So whilst maybe I was doing disservice by saying it's about the order, even the substance points aren't the points that we're raising. So that gives this court a different lens through which to hopefully now see that the forensic concern that was raised and the concern in Coles is misplaced, because actually really it's a policy concern. Because the concern of Coles is this is going to drive a coach and horses through redundancy. So to return to one other authority, this is a Rossendale, which is a domestic authority, just in terms of domestic interpretation, at page 41 of the authorities bundle.
This is your point that the Supreme Court have endorsed the purposive construction for domestic legislation as well as European legislation.
Yes, so perhaps the direction of travel is getting narrower, but it's also a point which is, if you look at, that is the point, but the quotation is important, because if we look at the words at page 41, I should hasten to add that obviously there's more than this. Lord Justice Singh, I think you referred to Uber recently in one of your judgments. His name escapes me, but effectively everyone's singing from the same hymn sheet, saying the same thing. But what's interesting is the bit sidelined, but the quotation from Lord Bingham and also from Lord Mans. Every statute other than a pure consolidation statute is, after all, enacted to make some change or address some problem or remove some blemish or affect some improvement in national life. The court's task with permissible bounds of interpretation is to give effect to Parliament's purpose. Obviously, it continues that controversial provisions. It means we submit the provisions at issue as opposed to those that cause controversy as such. Should be read in the context of statute as a whole, and statute they should be read in the historical context. And Lord Mant says over the page, at page 42, statutory purpose and general scheme functions are of central importance. Notions of a word having natural meanings, not necessarily, not always a helpful starting point. And the reason I bring you to this is, yes, purpose of construction, you've already got that point, my lord, but it goes back to these basics, which is it's enacted to make some change, address some problem, remove some blemish. And I don't think it can seriously be said that one needed the agency worker rights to tell hirers, by the way, make sure that your vacancies are just publicly viewable on a circular notice board, which is effectively all that this case achieves if the respondent is correct. It seems a lot of verbiage to achieve not very much. And the answer is that yes, of course, there may be other hirers that take a different view and allow you to apply, but the nature of legislation is to effect a change, not just allow the status quo to continue. I'm conscious of the time. I should be drawing to a close. I've addressed your lordships briefly on the facts. Obviously, I've addressed your lordships on the agency worker regulations and the directives. Those are strands 1 and 2. To briefly make the point about modern recruitment practices, which is following on from the Rossendale point, the whole point, this is certainly the case with EU law, and we submit now it is becoming more so the case with domestic law. It is interpreted, EU law, as that relevant at the time. So yes, we had the issue 20, 30 years ago discussing, but the nature of EU law is, unlike our Parliament, although it might be debated to a certain extent, they can't affect a change after a case has been decided, certainly not a member state, and even if you make a reference, they don't affect changes to the legislation. They interpret the legislation with the current modern context. And why we say that is relevant is, back to the point that I've made, it can't seriously be suggested that employers are routinely not informing candidates of a vacancy. It seems that modern recruitment practice is, you either put it on the notice board, you put it on your intranet, you send an email round. There is no suggestion that we're now in a world, we submit, where recruitment practice is such that we need legislation to say, make sure everyone can see it, because that's all that's achieved. So that's a legitimate argument to have regard to. And when one says, well, the value of this in this particular case is when the external when it's an external post, my client can apply, so there is some value about having the information at that stage. One, that's not the facts because it's not a post that we're concerned with. And two, the whole purpose of an external recruitment is to make something widely visible, to get applicants because you couldn't get them from within. The whole world that we now live in with aggregate search engines for jobs and so on is, if people are interested in a particular employer, they will receive that straight away. They put whatever the criteria is, whatever the employer is, and they find out. So the EAT and the respondent is bending over backwards to try to find some value in information in and of itself. That's not the world that we live in.
Well, hang on a minute. We have to construe the regulation, possibly the directive, as they're written. I mean, it's perhaps a little quaint reading it in 2022 that there should be reference to posting things on a notice board. You say nobody does that anymore, but that's all they're required to do.
Yeah.
What you say about modern employment practice may be right, but it doesn't help us answer the question in this case, does it?
Well, we submit it does. And the reason isn't because, yes, we accept you read the words in terms of they are. And in our modern practice, it might not be the notice board, it might be the email circular, whatever it is. But effectively, all that's being required, according to the respondent's argument, is everybody being aware of a vacancy. And it can't be really considered that there was a position where they weren't telling people of a vacancy. So effectively, what we have is a change. We submit no change. And then when we consider it in its current context, which we submit we're allowed to by virtue of it being EU law, this court should go further and find actually no, to give someone the same opportunity, a comparable worker, I think I've used the word slightly out of quoted precisely, to give the agency worker the same opportunity as a comparable worker to find permanent employment must be more than just giving them information and in the same breath saying they can't apply. And then the fourth strand of the argument was the consequences, and I've in large part dealt with those. I just want to deal with Kocur number 1.
Yes.
Because that was one of the arguments raised. And I think it's, if one turns to the respondent's skeleton at page 39 of the court bundle, the respondents placed some reliance on what was then number 1 in respect of Article 5, which it says should be read across. The problem, or the answer to this, is that case or that argument was, if the appellant had succeeded in that case, he as an agency worker would have ended up with the fixed hours.
Yes.
And that's completely different. That is affecting the agency model, because it's saying you can have agency workers, but they have to be given certain rights. In this case, one isn't affecting the agency work model because it's the vacancy on the terms that they want. So it's of no relevance to the present issue in terms of the proportionality and the flexibility arguments.
This comes back to your fundamental proposition that the employer is free to have any selection criteria they wish to, except your status as an agency worker.
Yes. So, bear with me one moment to check I haven't missed anything off before concluding.
Just on Kocur number 1, the key points that Lord Justice Underhill came to was perhaps the question we've got to ask ourselves, which is not what is a good idea, but what the Council and the Parliament did, which is really reflected in the last sentence of paragraph 31, cited in paragraph 27 of the respondent's relative. The question is whether the directives and the regulation have struck the balance in the way that the claimants say. We're not concerned with whether your solution is a good one or a bad one. I mean, I can see great merit in it. It's the question is simply what balance was struck at the time. Now, I understand your point about it, if you like, it's a moving feast. We have to look at this in a modern, up-to-date way, but perhaps might be countered for by Article 9. It's up to the member states to adapt and adopt and go further. And they have that right. And if they had done so, Regulation 30 would be in different terms to Article 6, and that would be perfectly fine. The question of us is what they did at the time.
That may be so, but one, what they did at the time is consistent with what we're asking the court to do.
Absolutely, if you're right, then you're right.
And also, it can't, one has to go back to the fundamental point that's in our skeleton argument. I think this is an important aspect that answers your Lordship's point. If one turns to page 20, and paragraph 16.
Yeah.
Now, my learned friend, Mr. David Reed, QC, accepts the teleological interpretation, but it must be understood that, as stated in the skeleton, this fundamentally requires the very purpose of the right interpretation. That purpose of interpretation is broader than our ordinary domestic one. there is no need for this ambiguity as such. So that's in part a response to your question about, well, what words have they used and what they say at the time. So you don't need to start from a position of ambiguity. It takes on the label effective, interpretation choosing to best ensure the effectiveness of the provisions. Pausing there, this is, we submit a general principle of effectiveness that affects much of community or EU law and how things are interpreted. And also sometimes referred to as consequentialist, the focus being on the consequences that flow from the interpretive choice. So we submit that you can embark on the exercise and have regard to what's been referred to as policy in our arguments. We would relabel it as purpose, and that is all part of the duty of this court and what it can do to arrive at that. That is greater than a simple domestic view of purpose, just from the words. So that is our primary response to the point. And the secondary response is you go back to what is in the regulations themselves, and the wording of those regulations goes so much further than the respondent's argument necessitates. And the general domestic provisions, ignoring my EU point, is words are used for a reason. Now, you're putting it to me, my lord, as if that goes against me. I'm lobbing it back to actually that goes for me. Because why do we have all the other words? So those are the two responses. And that leads to our conclusion, which is that the appeal should be allowed. What we're asking for is not the flexibility that is destroying, which is fundamental to the respondent's argument, and potentially fundamental to the points my lordships have put to me, which is, well, does this affect things? And the Employment Tribunal, if one returns to page 159 of the core bundle, are correct insofar as they come to their conclusions at paragraphs 86 to 89. And in particular, what they stress, the tribunal at first instance there at paragraphs 87, the respondent's submission is that the duty is only to inform and it is complied with that duty. That is the plain meaning of the regulations. It has a freedom to set conditions of applications permanent employees only can apply. That position is supported by, or said to be supported by, the relevant. We do not accept that. The right to be informed is to give that opportunity, to give that agency worker the same opportunity. So we're not doing violence to the language. We are allowing the language to have some use. And then obviously it continues with the BIS guidance point which I made and concludes at paragraph 90. The right's clearly infringed, and this is the second occasion which Tribunal held to be the case, although the last occasion was on a concession. So our appeal and our ground is the only way to actually give any purpose and any point to the same opportunity. Because opportunity has to lead to a result. It's a result-based word we submit. Information for information's sake, when you have no opportunity to apply, is not the same opportunity. And those are our submissions, my lords.
Mr. Caden. We've been firing questions at you almost from the moment you've got your feet. So if you want to take a moment or two to look at your skeleton and see whether there's anything you've forgotten, I'll ask my lords if they have any questions. I think we've covered the ground, actually.
Yes, we've got to the end, even if the route was slightly different. I hope that proves when I get the result from this case.
Thank you very much. We'll just rise for a short time.
Streaming just remains on for a short while.
full day.
It's a full day.
Yeah. Sorry, you've been told it's a holiday.
No, it just seemed like it was going quickly.
Oh, okay. Sorry.
You said you'd finished.
Well, okay. Maybe it went. I thought it was about right timing. But you've got enough.
Sorry?
The client was just asking, is it only listed for half a day?
No, it's listed for a
It's
day.
full day.
Oh,
Yeah,
so
5 hours.
Oh,
Yeah.
you have lunch, and then
Yeah,
you
you're fine.
you have a drink. Don't worry. Have a few drinks. In fact, I'd encourage that.
Oh, so you're going to speak again this afternoon?
No, my learned friend, Mr. David Reed, is going to tell me why I'm wrong. And then I will speak eventually, very shortly this afternoon, potentially.
Oh, I'm going back.
Right. Oh, sorry, yeah.
Let's get started. Sorry. Sorry, David.
No, you did say quick. I mean, I'm expecting them to be back in a second. Okay, right.
Yeah, I think
Sorry,
they'll be back in a couple of minutes.
Sure. Right. I don't think the recording stopped, right? The recording's still running?
Yeah.
You're
Okay.
absolutely right. Oh, it's okay. Thank you very much. Yeah. We've had it.
Okay.
Are you just going outside?
Just for 1 minute,
Just
yeah.
there.
And then we'll come back straight away.
Okay.
Probably because they're recording. They want to talk privately.
Yeah, I know, but this one's just. About 2 minutes.
So they went out for a chat.
I think so. Yeah, you just go and grab them. Oh, let's come back. Just think what I'll run. You get them. Is there that time when they went to the toilet?
That's much better. Thank you very much. I'd love to have you more directed on that seems to have done a trick, really.
Oh, does he have one? Oh no, he does. Next at the other side of the lamp.
I think what I said, and I never remember, is that if you have a mirror effect,
But the centre judge doesn't.
cumulative, and if you just sort of have two and then don't do anything else, it's not as effective as having two and then another 2 4 hours. It sort of builds up in your system.
But you still mustn't have 4.
Ibuprofen. You can't have too many, but the ibuprofen works better if you keep it kept up.
I didn't know that. I tend to do the
Another last. Yeah.
Yeah.
He has water.
But you can take both together, which is also good.
But how could they forget the centre judge?
But it is,
He
yes,
has got some. He's got a glass.
Oh,
it's better, thank you very much. So, there is
can hear them.
are they still busy with litigation?
Well, I thought I could hear them.
Ringing things. Like Bogey and Bachelor.
I was standing next to the meter. It was so
There's anything wrong with them for ages, but then they may not have anything for my exalted status. Yeah. Well, I suppose.
yeah. I would turn around and tell Tim that it's on my stream, but like, what should do?
How you went up or down?
And they were.
I thought it was right upstairs.
It was. Should I check?
Do you think you've turned it down?
I just, it's probably because we're so close to this bit, that's why. Should I just check?
You have a look from here. Go on then.
They use
Sorry, we've taken you by surprise. But
We'll just get in.
Yes. Sorry, Mr. Caden, our fault. We should have looked round the corner to see whether you were still there. Right. Now, Mr. Reid, we have your... do sit down, everyone, except Mr. Reid. Mr. Reid, we have your skeleton, and it's very helpful. Thank you very much. What we would particularly like your help on is this. If one looks at Regulation 13.1,
Yes.
If your side's case is right,
Yes.
then why didn't the draftsman, the legislator, the minister, simply say an agency worker has during an assignment the right to be informed by the hirer of any relevant vacant posts with the hirer? Full stop. End of message.
Yes. Well, I have to down a very simple answer to that, and it's reflective that the reason we're having that debate is to see a subsequent sentence that is explains the preceding sentence is an unusual form of drafting in English legislation. But actually, if you go to the directive, you see that exactly the same effective wording appears within the directive. And what's happened is they've mirrored it. And it isn't intended to create what my learned friend has skillfully constructed, an artifice of rights for something which wasn't expressly articulated there. So Article 6 says exactly to the same effect, to give them the same opportunity as other workers in that undertaking to find permanent employment. And we find in 13 the same opportunity as a comparable worker to find permanent employment with a hirer. I've used a model of comparable worker, and there's a reason for that, which I'll come on to, as to why they've slightly extended it out. But I say it's no more than, and we've seen it in some occasions, it happened with the original QP, that the drafters, I think slightly perplexed of the original GP regulations in 1981 of that directive, replicated some of the wording directly from the directive rather than attempting to articulate it out, which in itself caused much consternation for many years in relation to matters. But I have to say, I have my simple explanation is that the directive used a different form of drafting, that those drafting the directive were simply explaining the purpose. And actually, it's very important to see the purpose when you see it in the context of what's really going on. And it strays beyond the answer to your question, but I think it helps really to understand this. I was going to make 3 points. One of the points has been made rather more articulately by Justice Green, which is the background to these regulations. And you do see in the recital the difficulties about getting agreement and the fact that the objective was to strike a balance. But it's worth recognising that the balance is being applied in a tripartite relationship. We should never forget that. But its critical feature of this is that in any agency relationship, there are three parties. There's obviously the individual agency worker. There is the agency employer who employs that agency worker. And there is the hirer. And when we look at that balance, a significant feature of the balance that's being used here is representing a balance between those three groups. The individual agency worker and an agency worker's right to choose to work as an agency worker and have that opportunity, also to have protection. The business of being an agency and also the rights of the hirer. Now I say the business of being the agency because when we looked at the balance, the article we didn't look at is Article 2. And if you look at Article 2 and the aim of the legislation, you see that balance being articulated in very clear terms. And I'm interested by this phrase. It talks about the principle of equal treatment as set out in Article 5. Forced to note, the Article 5 equal treatment principle is nothing like the principle that my learned friend is seeking for, is applied to temporary agency workers by recognising, and this is a key point I made, I'm sorry, it's page 3, temporary work agencies as employers. So one of the things that this is doing is recognising that intermediate entity as a relevant party in the balance, temporary work agency employers. And it's noticeable that when you look in the directive at Article 5 and the principle of equal treatment, of course, it's concerned about equal treatment by that entity, by the agency employer, because that's the person with whom the agency worker has an employment relationship. And it's creating a treatment there to say, well, if you're an agency employer, when you place an agency worker in an establishment, you have to ensure that there are basic rights which are reflective of the rights of permanent workers. But that's all about regulating control of the agency employer.
So the Article 5 rights are against the agency only, not against the hirer.
Because that's who it's got the relationship with.
Yes.
The relevance of the employer there is only that its permanent employees set a model against which certain bedrock rights can't be worse.
Yes.
And a pause to note, although that's captured equal treatment, and it's a point we'll come on to in a moment, of course, equal treatment is a little bit of a misnomer, because this section is not creating equal treatment between agency workers and those in employment. It's creating a bedrock of rights to say you won't have lesser rights. The agency workers earn more than the permanent employees, as is frequently the case. That isn't a problem. It wasn't directing a provision that said agency workers and permanent workers have to be treated exactly the same, because if they'd done that, they would have effectively negated the purpose of agency workers completely. And they clearly weren't trying to do that. They were identifying a place in the modern economy for the agency worker and the agency employer. Now, the reason I've gone there is that when we look at Article 6, actually, Article 6 has to be looked at with 1, 2, and 3 together. It's right, a little group of rights of a different nature, but 1, 2, and 3 are all about access to employment. In this context, it's probably easiest to give an example. I entirely accept that interpretation is not about examples, but it just helps to do. If I'm a haulage company and I have permanent lorry drivers, I may have a need for some flexibility to have additional lorry drivers. And I choose to go to a lorry driving agency, and that lorry driving agency employs agency drivers who it's recruited, possibly in the modern world of shortage of HGV, might have even trained the agency workers, and it makes its income about supplying them to me and making a charge. Now, typically, one of my biggest concerns would be that I don't see my agency workers who I've trained and are making money out of suddenly get employment with the hirer. And it's not then surprising that I sometimes try and put barriers to stop that happening. I might not want my agency workers being aware of permanent jobs that are available there. I might want to put a contractual term in that says you can't employ any of my agency workers. If you look at 1, 2, and 3 together, you'll see what they're trying to do is regulate agencies so there are certain ground rules. 2 is critical. Member states should take action requiring to ensure that any clauses prohibiting or having the effect of preventing the conclusion of a contract of employment or an employment relationship between the user undertaking and the temporary agency worker are null and void and should be declared null and void. Agency workers can't be stopped from contracting with the end user.
I'm so sorry. Where were you reading?
It's little 2, Article 6.1.2.
6.2.
Now, okay, I can't stop you employing them. Can I charge you something if you take my drivers on? Well, if you look at the next paragraph, it says, this paragraph is without prejudice to provisions under which the temporary agencies receive a reasonable level of recompense for services rendered to the user undertakings for the assignment, recruitment and training of temporary agency workers. So I can charge you. I can't stop you employing permanently one of my drivers, but I can charge you if I've lost one of my drivers. Not an uncommon feature. And then there needs to be some protection to make sure my agency workers are aware if there are any jobs around. And that's what 1 does. It makes it absolutely clear that, and this is the only thing that's touching the hirer here, they have to be aware of jobs. I can't put in a restriction to say those agency lorry drivers, they have to have the same opportunity of knowing of other workers of permanent positions available. So again, if I just took that example and add another feature into it, which really goes to show why this is an important right. Suppose instead of there being 2 categories of worker in my driving company, there are 3. There are full-time permanent employees in the traditional model, and there are then, we've heard Uber, there are that intermediate category of individuals who are not full-time employees but have a slightly looser relationship and are workers, the intermediate role. So I've got some of those too. I've got people who I have a contract with which says you can come and drive if you want to drive, there's no obligation to come and drive, but they're workers in that middle sense. And then I've got some agency workers. Now, if you look at Regulation 13, we have used there the definition of workers and employees to make sure that if I'm offering jobs to the people who are the intermediate category, or I'm offering you permanent jobs, all the agency workers are aware of that. That's quite an important right. This facts of this case make you think that the only alternative is advertising to the wider world. But in a more sophisticated workplace, actually there may be jobs being offered to different categories in the nature of, they're doing the same basic job, but they might have different legal statuses. Whereas what Article 6 is doing is making sure that those who work there as agency workers have the opportunity of the knowledge of permanent jobs. Now, Article 6, going back to that balance, has only gone so far down that road. If they wanted to go further and impose a restriction on the end hirer, there's nothing magical about the wording of anti-discrimination legislation. The directive could have simply said it. It could have simply said, and the hirer shall not discriminate against prospective employees on the ground that they are or were agency workers. We just don't find that wording there. What they've done is have a very limited impact on the end user in terms of flexibility. There's nothing here that stops you choosing to use agency workers. There's nothing that stops you choosing to employ or not employ any of the agency workers. The only things that it seeks to do are to stop an absolute legal barrier, saying you can't stop them, but it seems to allow the ability to the intermediate agency to charge if you lose people, but that is a balance that's being struck between the interests of the agency worker, knowledge, accessibility, the interests of the intermediate agency, don't lose our workforce, and the freedom of the end employer to choose who to to employ on what terms. It's not an easy balance, and they've drawn it with 3 threads. And Article 6 tells us, in Article 6.1, what the limited nature of Article 1 is. It's just about opportunity by way of information. And we've just replicated it in Regulation 13. That's a short answer, I'm afraid, to this. And the problem my learned friend's got is that he, with great eloquence, and he shouldn't give up the day job of being a barrister, with great eloquence, he's woven the idea that there's some principle of non-discriminatory treatment. Well, we know from the directive that there is a subheading called principle of equal treatment, but it's very limited because it doesn't entirely equate terms, and it only applies in relation to the intermediate agency.
Because Article 5 uses the phrase "at least."
I'm sorry?
Article 5 uses the phrase "at least."
Yes.
So that's not actually equality. That's minimum rights.
You're absolutely right, because
that's the point you're making.
It is, and that's because there's a tendency to use the phrase equality in a very loose sense, because obviously there are different models. So if you have an equality model that's based around, say, gender, if I treat a female worker more favourably than a male worker, that's discrimination against a male worker, right? It's equal treatment. And then there's a model, for example, disability, where if I treat a disabled worker more favourably than an able-bodied worker, actually that's not unlawful because it's a one-way street. He has to create in this the implication of a discrimination model out of Article 6 that's a one-way street model. He has to say, well, inevitably, to answer your question, and it came out with 3 questions from your lordships, he isn't just saying opportunity, he isn't just saying the corollary right to be considered, he effectively has to say that based upon Article 6 and the addition of replicable wording within Regulation 13, that what's created there is an obligation on the hirer, who we see no other obligations on in relation to this, that they will not discriminate adversely on the grounds of an individual's, well, pause there, agency status, current agency status, or past agency status. Because as Lord Justice Bean identified, Regulation 13 talks about being made aware while you're an agency worker, but where does my learned friend's discrimination right go? If I'm made aware of the job, this is the day one right. If I come to work for your organisation on an assignment for 1 shift, and during the 1 shift, I'm aware that there are some permanent jobs being appointed, when I leave the following day, I'm no longer on an assignment with you, but does my learned friend's interpretation mean that the discrimination right of the opportunity has to go beyond that 1 assignment to say that it's discriminate not only about my current status on assignment, but also the fact that I had been on an assignment in the past. And so what we've suddenly created is an entirely freestanding anti-discrimination right based around adverse treatment. And it may be absolutely the right thing to do, but we're not in the exercise of reshaping what the draft...
Well, you say that, Mr. Reid, but there is a general principle of EU law of equality.
There is, I agree.
So why can't we deploy that in the interpretation and application of this particular directive?
Well, there is a general principle of equality, and indeed in the recitals, that's recognised because it's part of the social fabric of the community, and part of the objective of that social fabric was to look at, it's in the recitals, as part of the fundamental social charter of the rights of workers, there was the objective of achieving harmonised progress on conditions in respect of forms of work such as fixed-term contract work, part-time work, temporary agency work and seasonal work. And some of those prove less difficult than others from the point of view of reaching agreement. It's quite clear that reaching agreement about the structure of protection of temporary agency work in that framework was more challenging. And it would be odd if one took the general principles of equality of treatment in terms of particular categories or states by reason of gender, race, equality, sexual orientation, age, whatever, took that principle of equal treatment and shoehorned into the directive so that actually it crossed over that very careful balancing exercise where, had the directive intended to create an equality of treatment obligation, it could have simply said it. It could have simply said, no one shall discriminate in selection for employment or in the terms offered on the grounds that someone was or is an agency worker.
Can we just look at the wording of Article 6.1 again?
Yes.
And I want to ask you about the word same, because the wording used by the community legislature is not to give them the opportunity to find permanent employment or anything of that sort. It is to give them the same opportunity as other workers in that undertaking.
Yes.
What on your submission, if any, is the significance of same?
Well, it's because, as I sort of see the danger that might have been identified in looking at it, is that if an employer is looking for general recruits and opening in the market, the agency worker is going to see that whatever. That the need to access employment for the agency worker is the danger that an employer shields or hides from the agency worker the fact that it's making opportunities available for employment selectively to people. And that's why it's looking at a workplace and saying, in this workplace where people are engaged in agency workers and other workers, they should have the same opportunity as others there. And so there is a principle of equality of treatment in relation to knowledge, but there isn't a principle of equality of treatment in relation to being considered for the role.
I just wanted to ask you one final point, if I may,
Yes.
on this topic. You pointed out and reminded us that the definition of those who are permanent is not confined to employees.
Yes, only on this regulation.
I understand. And I've seen that the interpretation of worker in Regulation 2 is the one that one commonly finds in employment legislation. I think it's the case that judges are now workers, although we're not employees.
I'm sorry, say that.
You need not address that.
No. Worker is a wider definition.
Absolutely, it's a middle category.
I understand, yes. Now, what I wanted to ask you was that definition of worker one that was required by the directive, or was that something that we chose to do?
Well, we're in a bit of a vexing area there because worker is a community term of art,
yes.
And the directive uses the term worker.
Yes, that's what I thought.
I suspect what's slightly interesting, but it's not our case here today, is that we have chosen to use a narrower term of than worker when it comes to comparative terms.
I see.
Whereas I think the directive, it may be the directive only deals with permanent people, but when we've gone with the wider definition, we've replicated more closely the obligation and the community law, which, although it's not the same as our worker definition, definitely on the case law contemplates a wider term of relationship with employee. It is worth just looking a little bit closely about 13 because it is slightly odd in this respect. If you look at 2, the conditions is on page 18. It says, for the purpose of paragraph 1, an individual is a comparable worker in relation to an agency worker if at the time when the breach of paragraph 1 is alleged to take place, both the individual and the agency worker are working for and under the supervision of the direction of the hirer, so we've got the same entity, and are engaged in the same or broadly similar work, having regard whether they have similar level of qualification and skills, something that's strangely a nod towards equal pay. And then we have this: the individual works or is based on the same circumstances, and that individual is an employee of the hirer, or where there is no employee satisfying the requirements of A and B, is a worker of the hirer and satisfies those requirements. So you only ever look for workers if there are no employees doing the same job. What that slightly oddly means is this. If I go back to my example of the 3 types of driver, if I chose to offer permanent jobs only to the worker drivers, I wouldn't be in breach of this provision, because if I have to offer the opportunity to the employees there, I don't quite understand why we've drafted it that way. It's one of the odd structures of this legislation that it looks as though workers was only bolted on in order to catch a workplace where there wasn't an easy conventional comparator. But it's slightly odd because it seems to sort of narrow down the rights from Article 6, which seems, as we've looked, literally taken, would seem to suggest that if I've got a vacancy for CEO in Royal Mail, I have to post it on a board in order that the agency workers can see it. So we've definitely narrowed our format in relation to this.
Regulation 13 seems quite difficult to understand in some respects. The comparator must be someone who works or is based at the same establishment. But relevant vacant posts are not at the same, don't have to be at the same establishment. It might be anywhere in the country.
Quite right, I'd not thought about that before. You're absolutely right. I could have, in my example, I could have, my comparator could be a driver at, let's say, the Stoke Newington depot, where I'm an agency worker, and I might not have advertised any permanent jobs at the Stoke Newington depot. I might have advertised a permanent job in Stockton-on-Tees, but 13.1 would seem to suggest that I've got to make a general announcement in a suitable place in the hirer's establishment. 4 doesn't actually tell us what the establishment is.
It could be because Article 6.1 is very broad, that you have to notify vacancies in the quote user undertaking. Undertaking means the corporate entity in the broadest sense, and it's not geographically constrained in any way. Even if you construe 6.1 to apply only to comparable vacancies, it was to be comparable vacancies in the quote user undertaking.
Yes.
It could be in Stoke Newington or Stockport, you know.
Yes.
And that might be why you've got the lack
something
of
which is wider.
something broader
Yes.
than Regulation 13. That might be it.
Well, so we're back actually to being a bit more of a meaningful rights for agency workers than would otherwise be the case, because actually it's a right where they're treated more favourably than So to give the example of Royal Mail here, Royal Mail, we're obviously concerned with a slightly odd thing, which is the employer's negotiated position with the recognised union, that it has 2 tiers of permanent employees who are engaged in work. One who've got rostered shifts, and others who are the first line of flexible work. And you'll appreciate from the facts that the issue is that, thanks to the collective agreement with the union, if there's a vacancy in the rostered shifts, those who are the first tier of flexible workers get first choice on that role on length of service.
Maybe it does no more than assume mobility of labour.
I'm sorry?
It possibly assumes no more than broad mobility of labour.
Yes, but I suppose the answer that where the agency worker is slightly better off than this, in that if the agency worker is working here in the Leeds site actually the effect of Regulation 13, arguably, is that they have the right to know if there are permanent posts available in other sites, not just that particular site, even though the permanent job might have only been advertised to people on the particular site. 13 has some difficulties about it in terms of the way that it seems to be bolted together. But what I do say is one difficulty it doesn't have is the construct of creating a positive right against the hirer not to discriminate in relation to the selection of employment, because that would be a step entirely outside the scope of what we've seen on the directive to create a new model. And I entirely appreciate that my learned friend can point to the language within our Regulation 13 and say, what is the purpose of that sentence? And I think the EAT rightly said that his best point was to say, what's the purpose of that sentence? But I've already made the point, it's replication of the wording in the directive. But does the existence of that sentence create a construct that creates an implied obligation of an anti-discriminatory nature of the form that I've just described? And indeed, one wonders what the limits would be. He's talked about direct discrimination, but presumably it might also have to have some sort of implied discrimination, because if I'm in the example here, if the employer said, okay, well, the opportunities have been given to everybody, and you, the agency workers, are to apply for these permanent posts, but it's a condition of application that you are already a flexible worker. We haven't expressly said agency or anything else. Of course, you'd have to say, well, by implication, you are excluding agency workers from that consideration. And he almost came close to indirect discrimination when he talked about the problems of not having enough service as an agency worker to achieve that particular right. Well, we're a long way from the wording of Regulation 13 when we're in that particular construction. So I come back to my earlier point, which is there may have been very good policy reasons that could be argued for extending the protection for agency workers further than has. But actually, analysed, that's a balance that's been struck on the directive at a different point. And that's what the clear wording shows. And nothing about Regulation 13 extends that, acknowledging that they're harmonising provisions and they set a bedrock rather than cap on rights. And nothing about the directive dictates a wider interpretation on Regulation 13 that's been advanced.
Mr. Reid, I think otherwise we've got what you say in the skeleton argument, and unless there's anything else on your mind, that's all we wanted to ask you.
I'm grateful for the opportunity to exercise what was on my mind. I have to say, I think it is a relatively straightforward point on my analysis, and there's nothing more I can say by way of replication.
That's for you to say and us to decide. But,
absolutely right, and credit, as I said, to my learned friend for arguing a position which, on our position, is plainly contrary to the express wording. But I appreciate that's only, I would say that, wouldn't I?
Thank you very much. Mr. Caden, is anything you'd like to say in reply? In particular, I suppose Article 6.2 of the directive was a new topic which we haven't covered before. But anything else you'd like to say, not by way of repetition, but by way of reply?
Thank you, Miles. Yes. The first, dealing with the point about 6.2 and so on, our right to reply is that it's misplaced. And if we turn to the page 80 of the core bundle, paragraph 50E, and at the end of paragraph 50, it deals with these articles, and you'll see the bracketed bit. The rights conferred by Articles 6.2 and 6.3 are enacted into domestic law and the Employment Agencies Act 1973 and Conduct of Employment Agencies, Employment Business Regulations 2003. Yes. So the point being made is, the points, as eloquently put as they are not of relevance, because when we're dealing with the Agency Workers Regulations 2010, clearly they're not concerned with those aspects. That's not an answer to say, well, actually, that first part, in terms of the information part and the balance and so on that we're being proffered, is really in context, has to be viewed as those other two paragraphs, because there's legislation that already deals with it. It must be that the Agency Worker Regulations were dealing with the first part, and then you get to the arguments I made this morning about comparative same opportunity and so on. So that's our first point of reply. I think I only have two more, my lord. The second is, it was being proffered that there's some importance that there's using the words worker and not employee and so on. Now, as entertaining as the dance was, our fundamental position is it doesn't matter. Because when we're taking the non-discriminatory point of view, it must be accepted there's a hierarchy of statuses and rights. Employee, most rights, worker, as fewer, and then probably the most precarious being agency worker. All we're saying is they should have the opportunity, same opportunity, to be able to move their status. That's it. So it doesn't matter, even in this haulage example, if the only posts were these that are workers properly so called, it makes no difference to our argument, assuming the other dance that we made in terms of the hiring falling within those remits are met. I don't say it has to be permanent employment. We're fine with our submissions being they would be advertised at worker point and could not be discriminated against on the status. And that leads me to the final point, which is my learned friend mentioned about equal treatment being a flaw. It's not true equality in Article 5. And actually, that only helps our argument and hinders his, because then it makes perfect sense now that Article 6 is a separate article. Because on our reading, it does not want to be constrained by this flaw interpretation. It wants to be now applying the general equality principle. And that is an important one to have regard to, because the suggestion is that we are drafting or adding all these words and making it ever so complicated. And in fact, the general principle of equality is persons in similar positions should not be treated differently unless the difference in treatment can be objectively justified. So I'm not suggesting that the entire corpus of anti-discrimination law is now put in and there's all these bases. It's a very narrow one, which is the general principle of equality. So in other words, in this particular case, what we're saying is they are in similar positions, the very purpose of the argument, the very purpose of the rights, we say, and the very purpose of the legislation. Are they treated differently? Yes, one can apply, one cannot. Is that objectively justified? No, we haven't heard any particular reason why. So you can employ and rely on those. And that leads me to the sub-point before I'll sit down, which is...
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Queen's Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
Just wait a few seconds to see if that's repeated.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Queen's Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
Please continue, Mr. Caden.
Thank you. And this will be the final point, which is Lord Justice Singh asked my learned friend about the particular importance of the same, and it follows with opportunity. you've heard what we said about the words the same, but one word that, with respect, the respondent has been deathly silent on is the word opportunity. And I think it's probably obvious, but in case it isn't, an opportunity in ordinary language is an occasional situation to make it possible to do something that you want to do or have to do, or the possibility of doing something. From one of the dictionaries, I think this was the Cambridge Dictionary, it was the easiest one I had accessible.
Yeah.
The answer is, they've given no importance or reference to opportunity, even if they do their answer about why they've got the same. So those are our points of reply.
Thank you very much. Unless my lords have any questions, we're very grateful to both of you. We shall take these matters into consideration and send out in the usual way a draft judgment, not for re-argument, but for correction of typos and the like, and eventually we will hand the judgment down, probably remotely, but whether it's remotely or to an empty court, there'll be no need for anybody to attend. Thank you very much.
All right.